Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today, we are going to talk about a case that, according to the court, would be more proper to talk about in a daytime soap opera than it would be in an appellate case. Boy, what a mess it is. It basically boils down to a lawyer getting involved with her client, jealousy that attached to someone who is a spurned lover come to play in a way that is absolutely awesome in terms of its scope and magnitude. So let's take a look at the case and I'll give you my thoughts at the end. Okay, so this is the case Leslie Gunn versus Christine Drage, and it is from the Ninth Circuit Court of Appeals. It is an appeal from the United States District Court in Nevada. So this is how the opinion begins. Plaintiff appellant Leslie Gunn sued defendant appellee Christine Drage in California court alleging that Drage had interfered with a release and settlement agreement, RSA, entered into between Gunn and non-party Hans-Peter Wild. Drage subsequently moved to strike Gunn's complaint in its entirety pursuant to California's strategic lawsuit against public participation anti-SLAPP statute. The district court granted Drage's motion and dismissed Gunn's lawsuit with prejudice. It also denied Gunn's related motion for an extension of time to file her notice of appeal on its decision. The instant appeal concerns both district court decisions. After first concluding that Gunn's notice of appeal was timely, we find that the district court did not err in its analysis of the first step of Drage's anti-SLAPP motion and properly dismissed the actions. The facts of this case would not seem to be out of place as a plot of a daytime soap opera. They arise out of a love triangle between Gunn, her ex, Wild, a wealthy cis businessman, and Drage, Wild's former attorney and new girlfriend. Before 2016, Gunn and Wild had been involved in a close personal relationship and professional relationship for approximately 30 years. Sometime between 2015 and 2016, the exact dates are disputed, they decided to break up. To establish the terms of their breakup, on December 21st, 2015, they entered into a RSA, this release and settlement agreement. It provided, among other things, a bunch of money changing hands. We don't need to get into that. The RSA did not provide the parties with a clean break. Soon after its execution, both Wild and Gunn exchanged accusations of breach. According to Gunn, although she acknowledged receiving the $60 million gift in payment, soon after executing the RSA, Wild breached other provisions, and he did that almost immediately. So, mutual threats of litigation followed. Gunn was the first to expressly articulate these threats. As memorialized in a 2017 declaration that she submitted in connection with a separate action against Wild, she stated that, "In 2016, I told Wild I was planning on suing him for failure to pay me as obligated under the RSA." But then Wild beat her to the punch, initiating litigation in Europe on October 6, 2016. All of these things happened, and then against this backdrop, on October 15th, Wild reached out to Drage, an attorney. Drage, a founding member of Wild and Drage, a law firm specializing in complex business litigation, had become acquainted with Wild when, in 2011, she and W&D became litigation counsel for Wild-affiliated holdings. And Drage also became acquainted with Gunn. October 15, 2016, in an email, Wild informed Drage that because he was no longer in a relationship with Gunn, he would not pay any legal fees or costs she might incur. Drage advised Wild that she had not been working for Gunn and told him to reach out to her, Drage, if he ever needed anything. Both Wild and Drage assert that he did need something, namely legal services concerning Gunn and the RSA. At that time, Wild was contemplating numerous lawsuits concerning Gunn. Sometime during the month that Gunn filed this particular action, Wild and Drage also began a personal relationship. Gunn learned of the personal relationship between Drage and Wild on October 7, 2017. So in September of 2019, she filed the underlying action against Drage in Orange County Superior Court. Now that's state court in California. She alleged intentional interference with a contract and civil conspiracy. In her complaint, she alleged that despite Wild partially performing his obligations under the RSA, he breached many of the financial and non-financial terms of the RSA, and Wild breached the RSA by, among other things, failing and refusing to make annual tax-free gifts to Gunn. Gunn went on to contend that by virtue of her relationship with Wild, Drage became aware of the terms of the RSA and caused and persuaded Wild to breach in whole or in part. Later on, Drage removed the action to the Central District of California. I've done videos on this before, but basically removal is a process where you take a case out of state court and move it to federal court, and that's what happened here. It got removed to the Central District of California, and then in 2019 it was transferred by stipulation to the District of Nevada. So then Drage files this special motion to strike or dismiss Gunn's complaint in its entirety under the anti-SLAPP statute. So on April 10, 2020, the district court granted her motion. As the motion challenged the factual sufficiency of Gunn's complaint, the district court considered it to be one for summary judgment and applied California substantive law. First, the district court concluded that Drage had adequately established that Gunn's claims arose under protected activity, and then found also that because Drage indicated she had no knowledge of the RSA before Wild reached out to her in 2016, any communications between Wild and Drage regarding the RSA were thus necessarily driven by Wild's anticipation of litigation. Accordingly, Drage's alleged advice for Wild to breach the RSA occurred as a part of Drage's serious consideration of potential litigation and constituted protected conduct under the anti-SLAPP statute. So the lady files her notice of appeal. The court finds that it's untimely, doesn't grant an extension, and she appeals anyway. And so the first thing they had to determine was whether they had jurisdiction, because if Gunn's appeal is not timely filed, they do not have any jurisdiction. They decide that because an additional order was needed after the court announced its opinion, and that she had 30 days from the entry of judgment, that her appeal was indeed timely. And they take a lot of pages and quite a bit of ink to get to that point, but they could have said it in that few sentences. So then we move to the appeal and the actual merits of the appeal, and they can affirm on any grounds supported by the record. And the first thing courts do is they ask about whether the claim calls for the anti-SLAPP statute's protections, and if so, whether the claim has sufficient merit. California courts apply a burden-shifting framework to answer these questions. At the first step, the moving defendant must make a prima facie showing that the plaintiff's suit arises from an act in furtherance of the defendant's constitutional right to free speech. In making a prima facie showing, the movant defendant bears the burden of identifying all allegations of protected activity and plaintiff's claims for relief supported by them. Where the defendant satisfies her burden at the first step, the burden then shifts to the plaintiff to demonstrate that each challenge claim is based on protected activity is legally sufficient and factually substantiated. So she only appealed the first claim, the first part, whether it was under the anti-SLAPP statute. California's anti-SLAPP statute requires courts to consider evidence outside the pleadings, and that's what the court did. Now, Gunn makes a lot of claims that the court made a mistake in doing that, but that's not what the court actually finds. The court finds that if a defendant moves to strike on purely legal arguments, the courts have to analyze the motions under Rule 8 and 12. But where a defendant asserts a factual challenge, courts may treat that as a motion for summary judgment. And as I've mentioned in my video about summary judgment is a legal determination that irrespective of the facts not being in dispute, they're entitled to judgment as a matter of law. So the court would have allowed discovery. We now hold that these rules for anti-SLAPP motions apply in federal court regardless of whether a plaintiff challenges the first or second step of the anti-SLAPP analysis. So with that procedural issue out of the way, The district court correctly evaluated Drage's challenge as a factual one based on her own statements in her anti-SLAPP motion and her reliance on extrinsic evidence at both steps. The defendant determines which motion she files, not the plaintiff. The court was therefore entitled to consider evidence at both prongs. The first prong says you have to prove two things: whether the complaint alleges activity protected by the statute, and whether the cause or causes of action alleged arise from those activities. And so Drage was first required to identify what acts each challenge claim rests on, and then she identified both Gunn's challenge claims as resting on the allegation that she induced Wild to breach the RSA, because she can't sue Drage for a breach of the RSA just because she's ticked off that she is sleeping with her ex-boyfriend. So these acts, she contends, consisted of providing legal advice to Wild in her capacity as his attorney. In other words, that's what Drage says. Next, she had to show that those acts are protected under a statutorily defined category, and the statute provides that any written or oral statement or writing made before a legislative, executive, or judicial proceeding, or made in connection with an issue under consideration or review in such proceedings, is protected. And additionally, numerous cases have held that SLAPP statute protects lawyers sued for litigation related speech and activity. Statements made in preparation for litigation or anticipation of bringing an action fall within those categories too. In order for pre-litigation statements to be protected, courts have imposed the additional requirement that the contemplated litigation be seriously proposed in good faith for purposes of resolving the dispute. Under this broad standard, Drage's actions, including counseling Wild in anticipation of litigation, easily qualify. Both are protected activities when undertaken in connection with litigation seriously contemplated in good faith. When Wild purportedly reached out to Drage in October of 2016, litigation regarding the RSA was already ongoing, with more to follow in jurisdictions where Drage was licensed. Finally, there is no dispute that Gunn's claims arose under Drage's protected activities, since Drage's acts satisfying those elements form the basis for liability. Gunn insists that her complaint includes mixed causes of action with allegations that implicate unprotected activity. Unfortunately, Gunn is limited by her complaint. She didn't state those succinctly enough or clearly enough, and because Drage met her prima facie burden to show that all relief sought was based on allegations arising from protected activity, the district court properly struck Gunn's complaint in its entirety, and the order dismissing the case is affirmed. Well, I just have to say that the lawyer in this case, the one who was sued, has some significant problems. The legal rules say that you cannot engage in a romantic relationship, although they use another term. You cannot engage in a romantic relationship with a present client. And that's for a good reason. And the reason is because when you do that, you skew your objectivity. And because, particularly in the situation where someone might have fewer resources than the lawyer, in other words, the lawyer's rich, the client's poor, there could very well be a bit of, shall we say, exploitation, where the lawyer tends to induce certain favors instead of charging a fee. So it's done to protect the client. It's not done to protect the lawyer. And in this situation, she developed the relationship while she was working with the client actively, and that's a violation of the rules of the bar. Whether Nevada will ultimately go forward and discipline her license is another matter and beyond the scope of this video, but I would not do that. I mean, first of all, I'm married, I love my wife, I wouldn't do that. But people who do engage in this behavior take a huge risk with their law license, simply because they can be suspended or disbarred for this kind of conduct. And so one of the things that you should always remember if you're dealing with a lawyer and they come on to you is it's time to get another lawyer, because if they're willing to risk their law license, they're probably willing to do things that are riskier in your case too. So that's my little piece of advice for today. Thank you very much for watching. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know all the stuff we ask you to do. And as always, if you have the opportunity today, go out of your way to do something kind. Oh, and one further thing. Today, I am upgrading my editing computer. I'm getting a new Apple Silicon M2 chip. The maximum, it's the little 16-inch laptop MacBook Pro. And so I'm hoping that my video quality will go up a little bit with that. And I just wanted to share my good news with you. I hope you have a great day. Come get us down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.